Welcome everyone. It's terrific to see such a fantastic crowd here of both lawyers and anthropologists, and our special guest, Justice O'Brien. Thank you very much for making time available. I think we're going to have a really interesting 2 days, 1.5 days. So enjoy yourself, and what I would say is make sure you meet the other people on your table and they aren't people you already know. Part of what CNTA is about is networking and developing our community of practice so that we know people across the sector, not just in our own organisation. Mick, would you like to come and give a welcome?
Hi everyone. If you don't know me, my name's Mick O'Kane. I'm the Research Director for First Nations Legal and Research Services. Really happy to welcome everyone here for the conference, and many thanks to Julie and the CNTA for putting this on. It's a really great opportunity for us to get across some of the big issues in the field that we work in, together across the professions. I'd like to acknowledge the Aboriginal people of this place, who are the Wurundjeri Woiwurrung people, part of the Kulin Nation, and all of the other Aboriginal peoples of Victoria and the TOs that we work with, and hopefully we work for. And I'd like to acknowledge their elders, past, present, and emerging. I really hope you have a great time here, and it's such an interesting program to get through. I'm sure there'll be many opportunities for discussion about all of the subjects that will be raised. So thank you very much on behalf of First Nations Legal and Research Services, and welcome to the conference.
So I should have said who I was too, but most people know me, Julie Finlayson from the Centre for Native Title Anthropology. And I'd like to thank First Nations Legal and Research Services for their hospitality in co-hosting this. When I walked into the room yesterday, I went, wow, this must be the highlight of some of the venues we've had over the years. And it's certainly a terrific space. I also want to thank Right Edge, who were here yesterday setting up, and Sonia at the back here is going to do the recording and manage the IT during the day, which is another terrific first for us, because usually we're saying, put up your hand, does anyone know how to do X and Y? So having support like this is terrific. Some housekeeping before we start. The proceeds are being recorded. There are some people who are going to be online, but it's a select group, it's not a general forum. And shortly after this concludes, we will be putting up the proceedings on the CNTA website. There are session chairs who will time keep and manage the questions. They've already been contacted, so people know that. Sorry to interrupt. If you can't find a chair, take one from here and stick it on the table where you're allocated to. The toilets for anybody, you go straight down here to the end of the bar, and there's a little curtained area. Go through there, and then you'll find them at the end of the corridor, men on the left and women on the right. You can't get through the doors behind, they're locked. This is a co-shared space, so they have some security arrangements for all that. If there's an emergency, we all head straight out the front door, turn right and go down the lane and meet at the back of the building. I'm not expecting there will be, but just in case you need to know that. That's in Gore Street, if you're looking for the signage. There's a possibility of signing up on a sheet out at the desk if you'd like to join your colleagues for dinner tonight at the Grace Darling Hotel, which is straight down Smith Street. And I want to advertise to you something that the Federal Court has been championing, which is a brown bag event that they have over lunchtime for lawyers who are new in native title, and they have a program of unpacking certain of the processes, including some of the anthropological perspectives in that brown bag lunch. And I have some details about the remaining program for 2025. I really support this. It's really important to be talking with our colleagues in the other parts of the system. So I'll put some of the flyers out there if you'd like to pick one up. I've advertised it a couple of times on our CNTA email list, but I'd like more anthropologists to step up and say that they would do one. I'll just read out a couple to give you an idea of what they're about. So in June, there's court expectations in regard to hearing schedules. In October, there's case management hearings before judges. And there's also the duties of an expert anthropologist's objective opinions versus lawyer's role as an advocate. And Louise Allwood from the NLC is speaking about that. Special thanks to the chairs of sessions and also to Sheree Sharma, who's going to be an interlocutor with Justice O'Brien on the fireside chat. Now, there is a QR code on the screen. It's about to come up, I think. If you can link into that, that will give you the opportunity to do the poll later on about how you found the 2 days. The last housekeeping is that Petronella is not very well at the moment. I'm hoping to swap her around with somebody in the afternoon, but I can't see him here yet. Dane, are you here? No. So, okay, I'll make some arrangements about that. We'll still hear her paper, but it may not be this morning. So, any questions from anybody? Anything I've not covered? I can't see Tom here. Maybe he's in the same hotel. In that case, I think we might proceed with the fireside chat, if that's all right with you, Justice O'Brien and Sheree. Okay, thank you.
Hi, my name's Raina Matthews. I'm one of the co-principal legal officers at First Nations Legal and Research Services upstairs is our office. I'd like to begin this session by acknowledging the Wurundjeri Woiwurrung people and paying respects to their elders past, present and future. This is a fireside chat. Many of the highlights of my career as a native title lawyer have been by the fireside or by the campfire. It's a space for sharing stories, yarning. It's a good space to have a chat. So I invite you all to lean into the fire. If anyone's hungry, pull out a marshmallow. If you need a marshmallow stick, you can ask my kids where the best sticks are to put a marshmallow on the end of. I've also spoken to the building manager and they've assured me that the fire alarm has been turned off for this session, so we won't be sent out in an emergency to the front of the building. So without further ado, I'll pass it to Sheree Sharma and Justice O'Brien. Thank you.
Is it possible to move that lectern back just because I can't look at the people behind it?
Which is very important for a fireside chat, isn't it?
That's great. Thank you. Thank you. That's wonderful.
Julie, do we need the microphones for the recording or? Okay. I was wondering whether we could just project voices. Okay, well, thank you, Judge, for agreeing to be part of this discussion. I think you're fast becoming everyone's favourite native title judge for your very thoughtful explanation of anthropological concepts in the context of proving native title. I know your recent decisions in Western Kungaloo and in Stewart caused lots of very excited discussion within QSNTS's office, I'm sure amongst the other rep bodies as well. Oh, my screen's gone blank, I'm sorry. I might have to keep it alive. So there is a lot of interest in this session, I think, because we've got, as Julie, I'm sure, has explained, some new lawyers to the space, some old lawyers to the space, much like me, anthropologists as well, of course. We have some set questions that thank you for helping us put them together. So maybe we just get started. The federal court receives expert evidence in a number of disciplines. So obviously when we're thinking about native title, that might be expert evidence from historians, genealogists, but in this case, let's focus on the anthropological evidence. Are there differences in the form of presentation of anthropological evidence in comparison to other forms of expert evidence?
Thank you. And before I start answering the question, can I thank the CNTA for inviting me along to speak this morning in an informal way. I am conscious of my position as a relatively youthful judge in terms of native title cases. I'm sadly well on in years, but I've got a few miles on the road at this point. Although I'm relatively youthful in native title cases, I do have a long history of both preparing, presenting and adjudicating on expert evidence, particularly in the field of competition law, and receiving expert economic evidence. The late Professor Maureen Brunt, who was a very celebrated economist who worked in industrial economics and competition law, frequently wrote about the relationship between economists and lawyers. I was very interested to pick up the 2018 publication of Kingsley Palmer, Australian Native Title Anthropology, that many of you would know and will have read. And I was very interested to see that Kingsley Palmer wrote in very similar terms to Maureen Brunt about the relationship between anthropology and the law, in the way that Maureen used to write about economics and the law and just the challenges of the law speaking to those different areas of discipline. Kingsley Palmer wrote, "Seeking recognition of native title is a legal process. It's a matter filed with the court, mediated by the court and ultimately determined by the court. Accordingly, it is a business for lawyers." Now, there might be some lawyers in the room, but the rest of the anthropologists in the room probably don't like to hear that, but that is the circumstance. It's very similar to economics and the law. Kingsley Palmer went on to say it'll be members of the legal profession that decide how cases are to be run, how time and resources are to be apportioned, and ultimately how evidence will be presented to the court, including the evidence of experts. And so that brings us to the first question that you've posed, which is about the differences in the form and presentation of anthropological expert evidence in comparison to other forms of evidence. I'm going to give a little bit of a long answer, and it's a little bit of a run-up just to try and understand and unpack this, because I think the answer is there are differences in the form and presentation of anthropological evidence in comparison to other forms of expert evidence that the court often receives. And I think those differences do impact upon the manner in which the court receives and the acceptability of anthropological evidence to the court, and some of the challenges that the court has in receiving the evidence, and I think sometimes the challenges of anthropologists speaking to the court through their expert reports. So let me just though unpack it all a bit to explain why I think there are differences and why I think there are some challenges, and it's helpful to understand those differences and those challenges. Let me start with some things that I think are well understood, but there might be younger practitioners in the room and therefore may not be so well understood for them. The law treats evidence of opinions differently from evidence of what I'll describe as facts. So facts, of course, are what a person perceives by one of their senses, or what a person did or said or intended by certain actions, what's recorded in a document. In contrast to facts, a court will only receive evidence of an opinion in certain circumstances, and one of which is where a person has specialised knowledge, and the opinion is based upon that specialised knowledge that the person has. The court's willing to receive those sorts of opinions when they're based on specialist knowledge because the court recognises that certain issues that must be determined by the court involve that specialised knowledge, and an individual judge will not have that specialised knowledge. So the court's receptive to it in that circumstance. But even where the court's willing to receive the evidence of the opinion, the court is always attentive to differentiating between the matters of fact and matters of opinion. You might say it's an obsession of the court, and the court is always attentive to that. Why are we obsessed about that? It's because we consider that it's part of the judicial task to determine what the facts are or were likely to be, and it's no role of any witness that comes before the court, in a sense, to determine that question. So the court is always obsessed to understand what the facts are and what's being relied upon. So our practice note, which governs about the receipt of expert evidence, directs that an expert report should state the assumptions and material facts on which the opinion is expressed and is based. And the object of that direction in our practice note is to assist the court in readily identifying within an expert report what are the facts that the expert has assumed in coming to the particular opinions that the expert is expressing. Now here's where we get to the area where, why are anthropological reports a bit different from other sorts of reports that the court receives, and why does that sometimes cause some problems? And let me start with the observation that the court receives expert evidence in all sorts of disciplines. And so this is going beyond native title. So, for example, in patent cases, it's common for the court to receive what I'll call scientific expert, which involve the physical or the mathematical sciences. And typically those reports take a particular form. They're really quite standard form. There'll be a set of factual assumptions that the scientist is asked to assume, and then specific questions to answer based on those assumptions. And in reports of that kind, it's very easy for the court to distinguish between the assumed facts, which the scientist has been asked to assume, and the opinions that are expressed. In competition law cases that I've already mentioned, it's common for the court to receive evidence from economists, economic experts. Like anthropology, of course, economics is also a social science, not a physical or mathematical science, but it is concerned with the production and distribution of goods and services, and does have something of a mathematical underpinning. So it's not really in the same court completely as anthropological reports. And so again, often those sorts of reports start with a set of assumptions which are written out, factual assumptions, and the economist is asked to express their opinion on those assumptions. In those circumstances, again, the court can readily differentiate between facts and opinion, and it makes the court's task quite straightforward. I can say, though, in the field of economics, the court often receives reports that kind of interweave conclusions on facts that the economist has derived for themselves and statements of opinion, which sometimes then does make it difficult for the court to differentiate between the two. And in those circumstances, what sometimes happens are economists are also criticised by the court, both for their form of the report or the difficulty of understanding what was the basis of the opinions that are expressed, and that frequently happens. So then we come to anthropological reports. With that background, I apologise if that was too long a run-up, but anyway, that was the run-up to answering the question. But if I can generalise from my experience to date, anthropological reports very rarely conform to the law's preferred paradigm of what I've explained. That's not fatal, though, to the receipt of anthropological reports into evidence, but it does help, I think, explain to some extent why on occasions the form of anthropological evidence is sometimes criticised by the court, and sometimes the court gives it less weight and the like, and we have this problem of communication between anthropologists and the court. I wrote about this in one of the earlier judgments in Western Gungaloo. I can't remember which number it was, but it's 2022 FCA 827, where I endeavoured to collect the observations of numerous judges over the years, reflecting on the receipt of anthropological evidence. But the complexity, it seems to me, arises from the nature, of course, of the anthropological discipline. The different purposes often served by anthropological reports, and the different types of material that are presented in anthropological reports. So, as an illustration, anthropological reports frequently contain observations of primary facts, in particular what the anthropologist was told by a particular informant. The reports also frequently contain a summary of historical records and literature, which are also essentially factual material. Often the reports will refer to or summarise witness evidence that's been given in the proceeding itself. The reports sometimes refer to earlier anthropological reports on the same or similar geographic area. And amongst all of that, the report will express opinions of various kinds. Some are about historical facts, some are about genealogical matters, some are about languages spoken or evidence of language use, some are about traditional laws and customs acknowledged and observed before or in the early phases of European settlement, some are about social organisation today and the continued acknowledgement and observance of traditional laws and customs. And the challenge that the court faces really is about unpicking these materials so that they can be used by the court in accordance with the accepted legal and judicial method of decision making, because there is in a sense, a specified and clear pathway for how courts do their business, which is the judicial method. And sometimes it's hard to do. The identification of the facts on which the opinions have been expressed and the opinions themselves can become very intermingled and very blurred. And what tends to happen, if the court can't clearly understand the factual basis for the opinions that are expressed, then the court may attribute less weight, indeed even little weight, to the opinion. And I think all of that are the challenges that are faced by the anthropological profession and indeed by the court in this method of communication that we have in the courtroom. That's a very lengthy answer.
No, I think it sets us up nicely for the next couple of questions. But I'm quite interested to understand, and we will get there in question 4, is how we might then be able to structure how we ask questions of an anthropologist so that those steps are potentially laid out in a report in a way that then assists the court. But we'll get to that point.
Yes.
Let's move to question 2, which is based around the concepts that you were just talking about. So opinion versus, I guess, the basis of that opinion. So we know the court distinguishes between the evidence that provides a basis for an expert opinion and the opinion itself. Just pausing there, should we give an example, I guess, in an anthropological context, if we can, the two lawyers can, about that sort of explains the basis versus the opinion?
Yes. So I mean, really, yes, lawyers and the courts use the word basis very commonly, and really, it is just another word for all of the facts that the expert anthropologist has taken into account before finally expressing an opinion of some kind, whatever that opinion might be. So the basis is are all of the facts taken into account.
So an anthropologist, you can shoot me down if I'm getting this wrong, but for example, could we say, if a report said something like, I spoke to informant X, informant Y and informant Z, and each say that they have acquired rights in their country through their mum or their dad, I now have an opinion that cognatic descent is the basis upon which people secure or acquire rights in country. In that statement, what would you say are what would you say is the basis, and what would you say is the opinion?
The basis are all the statements made by the informants.
Yep.
In totality.
Great.
Yes.
Okay.
Yep.
Okay. So we know that the basis should be based on admissible evidence. So admissible evidence is evidence that meets the requirements of admissibility under the law. Does that make sense to people who aren't lawyers or who are junior lawyers, perhaps? Yeah? Okay.
But even on that,
Yes.
when we come to some questions, I'm going to unpack that even a little bit more,
great.
because there's a little bit of subtlety in that as well. Which
Okay.
I think sometimes it can be overlooked, I found.
Okay.
Yeah.
Okay. Well, so I think this comment is useful then. So that if the basis is not based on admissible evidence, the opinion is not necessarily inadmissible, but it will have some impact on the weight that the court can give that evidence. So with all that context, how important is it for the facts forming the basis for the anthropological opinion to be proved by admissible evidence? What difficulties emerge for the court if the facts forming the basis for the opinion are not proved by admissible evidence? And I think the next point is pretty important. Is it permissible for lawyers to assist an anthropologist in collating the basis material to ensure that the opinion is then based on admissible evidence?
Yes. As you will have understood from my answer to the first question, and you'll probably guess my answer to the second question, I do think it is important, indeed, very important, for the facts forming the basis for an anthropological opinion to be proved by admissible evidence. If they're not, I have to say, for myself personally, and I think many of my fellow judges, will be inclined to give an opinion that depends upon material that the court doesn't recognise as admissible, will give it lesser weight. Now, the reason the court does that is because we just can't know, we don't have any confidence that this material, purportedly factual material, but not able to be admitted into evidence, is a true guide to the facts, and therefore the opinion therefore is only as good as the reliability of the facts on which it's based, and therefore the opinion gets undermined if the facts are not proved by admissible evidence. But now I want to sort of unpack this idea of admissible evidence a little bit more, because obviously for non-lawyers it's a bit of an unknown area and can be quite a fearful area of what do you mean by admissible evidence? Why is some evidence not admissible? You know, what's going on here? What does it all mean? Yes. And obviously the laws of evidence are very old in our English Australian common law tradition. They come from the common law. They're largely codified, not completely in a statute we call the Evidence Act now. But they are, in a sense, the rules of evidence are the collective wisdom from many decades, if not centuries, as to when courts can put confidence on material that's before the court as to whether it's likely to be reliable or not. So we have these rules. And one of the most important rules is the rule of hearsay. And by and large, the rule of hearsay says things that are said outside the court are not admissible. Now, that seems a bit ridiculous because lots of things that are said outside the court actually ultimately do end up getting into court, particularly in documentary form. But we have many exceptions to the rules of hearsay. And the exceptions have been developed to enable material to get into court and to get before a judge and be relied upon. But the rules and these exceptions are all quite finely tuned, and they're tuned to discerning, look, can we place some confidence on that material, and how much confidence can we place upon the material? So with things such as most of the historical information that anthropologists will rely upon in preparing their reports and expressing their opinions, most of that material is admissible in evidence. And one of the most, it can get into evidence in a number of ways, and I'm not going to go into the technicalities of the rules of evidence, but to make an obvious point that generally historical material where the author is no longer alive or not able to give evidence, in most circumstances, or it might be a government record, and there's other exceptions for government records, most of that material, there are exceptions to rules and hearsay, and it gets into evidence quite readily. And there's really no difficulty with that sort of material. But can I mention just two specific areas that I think do present difficulties, and as I say, in my limited experience to date, perhaps not quite, I feel not quite enough attention is given to these categories of evidence to ensure that they are as admissible as they can possibly be. And the first category, believe it or not, is evidence of statements made by informants to the anthropologist where the informant is available to give evidence but doesn't give evidence, or doesn't give evidence of the statements they've made to the anthropologist. Now, in my mind, that does present a difficulty, and I'm not quite sure why it's not attended to as carefully as it might be attended to. So can I distinguish between, obviously, informants who are no longer able to give evidence to the court, and they might have died in the meantime, and there's no difficulty with that. There's an exception to the hearsay rule to accept their evidence in those circumstances. So it's only evidence of informants who have given made statements to anthropologists, and over time, but for some reason those statements are not collected into a witness statement, for example, and then the informant is not asked to come along to court and confirm that evidence in court in any shape or form. So the evidence is what I call it, it's unsworn, it's not attested in any way. There's no explanation as to whether the informant is able to give evidence or is not able to give evidence. It just doesn't seem to be attended to at all. And even I find a little more strangely the circumstances where the informant has said a number of things to an anthropologist over the years, and the informant also gives evidence to court, but the two statements don't marry up at all. And it seems that the things that have been said over the years have been just ignored. I hesitate to say sadly by the lawyers, I don't know, by somebody. But that leaves the court in a very strange position, because this material strictly is not, it still gets before the court, but that causes the court to doubt it, to question why the informant is not giving this evidence in court, particularly if they're there. Are they views no longer held by the particular witness? It's just sort of unexplained. So that's one area that I have a bit of a problem with. The second category that I have, I think presents complexity, if I could say, is evidence of earlier anthropological reports in relation to the same or similar geographic area, which frequently comes up. Now, this category is actually a little more complex. And again, without going into the technicalities of the laws of evidence, but earlier anthropological reports may be accepted into evidence as part of the expert witness's report, but the weight that the court will give to the earlier report is likely to depend on a range of factors. Now, they're going to include the date that the earlier report was prepared. It might be quite historical, and therefore it's quite it might have benefit because it is quite historical. It was done in the 70s, for example, or the 60s, or the 50s, and has value because of what it was recording at that time. And of course, the court will accept that document, perhaps even the author is no longer alive, the anthropologist from that time, or the material that's recorded can't otherwise get into evidence in any other way. The maker of the statements is not available, and the evidence can get in that way. So that's one category where it's historical, but that's very important. Obviously, just generally, what another factor that's important is the reason that the author of the earlier report is not giving evidence. And again, that's related, of course, to the proximity of the date of that report, but that can be a very important factor for the court. And then the third category is precisely how that earlier report is being used by the current expert. And we have this distinction between our opinions being adopted, is reference being made to underlying material, but precisely what is the current anthropologist doing with that report and how it's being relied upon is also a very important question for the court. So just circling back to the short answer is it is very important, I think, for the facts that form the basis of the expert opinions to be admissible. In a large area, that's not so problematic, but there are a few areas, or a couple of areas at least, that I think it is strangely not attended to as closely as I think it ought to be.
Thank you, Judge. I think you've given all of us two take-home practical tips, which is when we are, as a cohort of people figuring out a short list of witnesses, we really need to be going back to previous written material from the anthropologists. And I guess in our space, often what happens is that there is, like you've said, a long time in between the start of a project in which an expert anthropologist might be engaged to assist the rep body understand the potential for a native title claim in an area, and the start time from which people might get out on the ground and start talking to the same people that were informants in that project, or to that research project. Or at least in QSNTS's space, it might be different in other rep bodies. But that is a really great tip, that the short list should start with the people that were the informants in that research project, in the anthropological report. It was really interesting what you said about the use of earlier anthropological reports and the muddying, I guess, of the waters when the current anthropologist uses that material. Are you saying that it's a bit difficult to understand whether, if using that the older material, it's unsure whether that's the basis for the opinion of the current anthropologist? Yes,
and as I say, there's a few factors here. So where it is an older anthropological work, something dating from the 20th century and earlier decades, then the use of it is usually quite clear and understood. It is, of course, I mean, necessarily there's a degree of second-hand use of information. What the court is always concerned about, in the court's obsession with the reliability of facts and evidence, the court filters all the material it receives. When the court receives an earlier anthropological report, the court, of course, understands that that's an expression of opinion, based upon material that anthropologist had regard to, and often some of that material is probably invisible. So it's already, in a sense, what you're receiving is an earlier expression of opinion where the basis for that opinion is unknown. Might be more limited, might be narrowed, and so you've already got a little bit of a handicap. But in a sense, if today's anthropologist is relying upon that opinion, necessarily today's anthropologist is also relying upon something of the assumed facts that supported that opinion. So you've got this chain of basis. Now, as I say, if it's an earlier report, let's assume the maker of that earlier report is no longer available to give evidence, then it will be admissible, but there will be some thinking to be done about, well, what were the circumstances in which that report was prepared, and indeed, I think I can say this, it might have been an academic work. It might have been a publication, of course, predates the native title era, might have nothing to do with native title, was just academic research. Alternatively, it might be a report that was associated with some commercial enterprise or some commercial activity. It might be questions about who commissioned the report, for what purpose. So you just have these range of questions which then might call into question, in a sense, the reliability of that report or its purpose. And then if the modern day opinion is being based on it, that may ultimately start to undermine the modern day opinion. I think the short point, without, I know I'm probably using up all our time on these first couple of questions. I know.
I've still got more questions for you.
But you can see why it's I find it quite a complex area as I unpick. Why has the anthropologist today sought to rely upon an earlier work? If it's gap-filling of a historical record, it'll be well understood, but it all depends on the nature and type of report and why it's being used and how it's being used, if that makes some sense.
It does make sense, but I might just draw it back to that sort of third point of that question, which was, is it permissible for lawyers to assist the anthropological experts in collating basis material and ensuring it's admissible? So what role then do the lawyers in the room have to ensure that is that sort of geared towards giving the anthropologist context around what's admissible, what's inadmissible, but also providing material? So as lawyers, we can get busy going around collecting the statements that then might form the basis for an opinion, and knowing, I guess, that those statements are collected, hopefully with knowledge in our heads around what's admissible and what's not. What role do we have in collating other materials, such as historical material or older reports? Should there be some forensic analysis from the lawyer's perspective before that material is included in an anthropologist's brief?
My own view is it's very important for lawyers to be involved. It's not only permissible for them to be involved in identifying and collating basis material, but it's also desirable. It's of course impermissible for lawyers to attempt to direct or instruct an expert about their opinion. It's completely off limits. But lawyers oughtn't to be shy about assisting expert witnesses in preparing their reports in an admissible form. That really is the role of lawyers. And that has been the view, certainly, of the Federal Court for almost as long as I've been in practice. I remember particularly in the field of competition law, which I practiced in extensively at the bar and whatnot, but senior judges have told me for eons the role of lawyers is to ensure that the expert report is admissible and is in the most acceptable form to the court, which requires attention and assistance by lawyers to guide the experts, including in draft reports, but seeking to identify what's being relied upon, what is all the material that's being relied upon, is it in an admissible form already? Historical material usually will be, but it's good for it to be listed and understood what it is. But if it's in these other areas, I think it's important for the lawyers to be turning their minds to, well, Okay, if this informant has said these things and I'm preparing a witness statement for the informant, at least ask the same questions of the informant to see whether the informant adheres to those views or not, as the case may be. But I think that's very important.
Great.
Yeah.
Okay, well, the next sort of two questions really are geared towards some really useful, I guess, practical matters. So before we move on to those, is there any questions from the floor, I guess, around the theory of basis first opinion? Oh, hi, Tom.
Can I apologise, Tom, that I think we've stolen your first slot, so...
I was working on 9:30, but anyway, never mind. I was going to ask this question, whether you would encourage the tender of all basis materials or not. I've done that in cases and not done it in cases. At times I get a sense from the bench that less is better. Don't burden me with an enormous volume of materials. Sometimes judges deal with it in the way of saying, well, okay, there's all this material here, but I'm only going to have regard to what you refer me to in submissions. I understand that. But having regard to what you've said about not being able to see the chain of basis as it goes along, do you encourage the tender of basis materials holus bolus?
I haven't, oops, I just lost my name tag. I haven't to date, but I'm reflecting on it, I must say, as I'm going along. And the reason that I'm reflecting on it really comes from this circumstance which you'll understand. Generally, all the material that the expert anthropologist has referred to can get in under the exception to hearsay as being part of the basis on which the expert has relied and get in on that way. But it's a little bit unsatisfactory for the reason I've explained, that when I'm actually thinking about that material, I'm still thinking about its ultimate admissibility and reliability in that context. And because it often slips in that sort of way, but is not formally tendered, and the court isn't asked to sort of adjudicate on it, in a sense, standalone admissibility. When you come to consider it, you find you have doubts about it, and it's problematic. If it were to be tendered formally, it would force, of course, the lawyers to think about its admissibility, its form, and I think a little bit about some of the problems that I've particularly identified. So, for example, if the basis material included informant statements or notes given to the anthropologists, if that were to be tendered, or if the process was going to be that the basis material was going to be tendered, I suspect greater attention would be given to who those informants were. Are they available to give evidence? Are they not available to give evidence? Why isn't there evidence in a witness statement if they are giving evidence in matters of that kind? If some of the material is earlier anthropological reports, I think greater attention would be given to everybody. Well, what exactly is the status of this report and the basis upon which it is being tendered and then relied upon? So it certainly is the case. The court will very rarely want to read from page 1 to page 10,000 all of the basis material that the expert witness has relied upon. But I am reflecting, and I haven't, I'm sorry it's not a really clear answer, but I think it is a matter of further thought that the process of at least listing or and possibly inviting a party to tender the basis material would force everybody to pay greater attention to the nature, quality, from an evidentiary point of view, of all of the material.
Yeah, thank you.
Maybe one more question before we move to the next part of the chat.
I have a question around the reliance on historical materials, and in particular, I'm thinking of the way in which we use the materials of earlier anthropologists from early, the likes of Radcliffe, Brown and so forth. And they're not simply to establish a set of facts, it seems to me, but to also address this critical question of continuity in native title. Speaking from experience in working with some of my colleagues from Western Australia in the Carnarvon region, where Radcliffe Brown developed his whole theory in his tome on 11 tribes of Western Australia. It's to show what the continuities, the attenuations, the losses, the adaptations, etc. are from their descendants, in order that the legal system can make a judgment, is this the relevant continuity that will meet native title guidelines? So I'm trying to work out in my mind why that is not perhaps legitimate, I got the sense, or whether it should be further examined by the court, because it seems to me these are foundational mechanisms to address one of the matters that the court has to deal with, in that case, continuity.
Yes, I didn't mean to give that impression completely. What I was trying to draw attention to, though, are the different types of historical material, and indeed different types of what we might say generally ethnographic or anthropological, expert or non-expert, academic or amateur, which of course everyone's familiar with over the decades, particularly of the 20th century, from the early 20th century, or frankly even the 19th century. But I was only trying to attend to that, to make a couple of obvious points. From the law's perspective, there won't be a difficulty with admissibility of that historical material, because the maker of the representations, it'll be in documentary form, the maker of the representation is obviously not available to give evidence, and therefore the material is admissible. But I was just trying to make a general observation, though, of course, the nature of the material, the circumstances in which it's prepared, the basis on which it was prepared. Was it done on the basis of direct field research, done on the basis of secondary material or tertiary material? All of those factors, of course, weigh into how the court has regard to that. But of course, all of that material is necessary in one sense, but then its fundamental reliability is ultimately a matter for the court. So it's that process of assessment of that basis material for the present day opinion and trying to work that out. So I hope that satisfactorily answers the question. Yep.
All right, well, we might move on to the next sort of set of questions. So generally in native title matters, an applicant will engage an independent expert, and then often the state might engage their own, well, it's not their own, but another independent expert to review the material provided by the applicant. But there is another option, which is the court appointing an expert to inquire into and report on any of the questions coming out of the proceeding. What is the role of that court-appointed expert? What are the benefits and limitations of doing that? And is it something that the parties should perhaps be thinking more carefully about and bringing that option to the court or request to the court?
Yes, I'm very happy to answer this question. As far as I'm aware, it's a relatively unexplored area in native title, but I think it is an area worthy of exploration. So our federal court rules make express provision for the court to appoint an expert, but in practice it's very rarely used. I had one encounter with it in practice myself in a class action where my opponent wanted to have a court-appointed expert. It was a very big class action a number of years ago now, but that would have denied my client, a very large bank, from calling its own expert. It wasn't too happy about doing that, and we resisted it, and ultimately the court didn't do it. but it is a facility that's there, and it strikes me that in the native title space, it might be an option that could be explored. Essentially, the effect of an expert report of a court-appointed expert can simply be to adduce admissible evidence of that expert that the court can rely upon. So in one sense, there's no difference for a court-appointed expert to a party-appointed expert, and the court can receive that expert report. And there are a number of reasons why it seems to me a court-appointed expert might assist in the resolution of native title claims. First, it avoids, of course, the highly adversarial approach of each party appointing their own expert, and the court then having to adjudicate between the competing opinions of the experts appointed by the parties. Secondly, and it's probably really a related point, it provides a mechanism for expert evidence to be given, might I say, in a more impartial manner. The expert has no stake in the game at all and comes to it simply with the duty to the court and to express an opinion on specified questions and specified material. And in some cases, that more impartial approach might suit all of the parties. And I'm thinking in particular of cases where the parties are agreed on a majority of issues, but there are isolated questions which the court still needs to determine, and they could be given to a court-appointed expert to express an opinion on. Thirdly, and obviously, it reduces the cost, the overall cost of the litigation. You have one expert, or potentially have one expert, rather than more. And mechanisms can be devised also where, with the agreement of everybody, the court and the parties, it need not necessarily foreclose the prospect of the parties adducing further expert evidence. I mean, there's really two options with the role. One is the court actually says we're appointing an expert and that's going to be the expert evidence on this case, but there are other hybrid mechanisms whereby that might a court-appointed expert might be called first, but it's possible for the parties to call further evidence. But of course, in given circumstances, the opinions expressed by the court-appointed expert may persuade the parties that no further evidence is necessary. As to what are the downsides of doing that, I do think the only real downside is whilst, of course, it may save cost, particularly if the court determines that that will be the only expert evidence able to be received on the case. If the parties insist and the court acquiesces to the parties keeping their options open, well, then there might be added cost, plainly, because the cost of the court-appointed expert will ultimately have to be borne by the parties. And if the parties then go on and appoint their own experts as well, then you've got actually an increase in costs. But as I say, this is not a procedural avenue that is used in courts very much. But it strikes me that it ought to be something that's thought about a bit more in native title. And can I say, it also is consistent with something of a pattern of the court today and the modern day courts, which the court is striving to streamline all litigation, and the court is conscious of getting assistance for the court in answering questions as quickly as I can. I'll just mention this by way of illustration of the point I'm making, but for a number of years now, the court has been quite keen on the idea of referring specific technical specialised questions out to referees. And the court's increasingly doing that. The difference between a referee and an expert is the referee prepares a report and then the court decides whether the court will adopt that decision-making by the referee. If I put it in very colloquial terms, it's a form of contracting out determination of particular issues, but which can be done. But another practice that one of my colleagues engaged in a class action involving Roundup was also to have, it's not referee, I've forgotten the technical word for it at the moment, it's not an advisor, it's, there's another word for it, but having an expert sit alongside the judge in the courtroom hearing the expert evidence to assist the judge understand the expert evidence. But all of that is simply to make the point, the court is striving to determine cases more efficiently, more quickly, at lower cost, and is very determined to do it. It just strikes me a court-appointed expert in the context of native title ought to be something that's considered by parties in the right cases. Of course, it halves the work that's available for the people in this room. I apologise about that, but it lowers the costs for everybody's clients, which is the most important thing.
Yeah, well, that's right. Okay, well, moving on to how we brief experts, whether they be court appointed or engaged separately by each party. I think everyone in this room knows this quote from the expert practice note. Any questions or assumptions provided to an expert should be provided in an unbiased manner and in such a way that the expert is not confined to addressing selective, irrelevant or immaterial issues. How do we get our questions in our terms of reference to experts? And I know we've got lawyers and in-house anthropologists here who are doing this as a day-to-day task, is drafting terms of reference. How do we get it right? And is there a role for the court in providing some guidance on the drafting of terms of reference?
The answer to the second question is I think definitely, and I'll come back to that. But the formulation of questions put to experts in all areas of the law, in my view, is very, very important for the ultimate receipt of that expert evidence. It's important that the questions are directed to the issues that the court must determine, first and foremost, and are framed in a legally relevant way for the court. And it's also important, in my view, that the experts called by each of the parties are addressing the same questions in that way. There are forms of questions, I think, that are useful, and there are forms of questions that I think are less than useful. My own view is that ideally the questions should be framed in the language of and using the concepts shaped by the Native Title Act, and of course with an obvious focus on the definition of native title in section 223 and the necessary integers of a native title determination in section 225. I think caution should be exercised in framing questions using non-statutory language, even where the language has been used in native title jurisprudence. And you'll know the obvious words, but questions framed using the words society or normative can create problems if no explanation is provided or definition is provided to the expert about the intended meaning of the words. And the reason that creates problems is that if no explanation or definition is provided, the court's got to work out what definition is the expert using, and is it the same definition that the court's required to use in native title jurisprudence? And that can be problematic. Obviously, questions are also problematic if they suggest an answer, and that's why the practice note talks about framed in an unbiased manner. And questions are also problematic if the question assumes that the answer is a necessary step or element of a finding of native title, which I've seen as well, when that may not be the case. So there can be problems with questions framed in that way, which drives me to this observation that all in all, I think open questions are preferable. Questions about the people who occupied the claim area before European settlement, including about their laws, about their customs and language, the nature of their rights and interests in land and waters and their connection to land and waters, expressed in that open way, and questions about the present day claim group, including their genealogical relationship to the people who occupied the area before European settlement, about their laws and their customs and their language and their rights and interests in the land and waters and their connection to the land and waters, asked in an open way. But it really is my strong preference in all cases involving expert evidence is for the parties to obtain the court's guidance on the form of questions to put to the experts before the experts are instructed. Indeed, my general approach is not to permit any party to adduce expert evidence without the leave of the court, which requires the court's approval to the form of questions. Now, that can, well, in some circumstances, can present difficulties when an anthropologist has been working with a particular group of people for a long time and potentially before court proceedings and the like. But certainly that's my general approach in all areas of law where I require expert evidence for the reasons that I've indicated. That I think the specification of the questions, having them appropriately tailored to what the court must determine in an unbiased manner, in an open manner, making no assumptions and nothing else. I think it's helpful to have the court's guidance on that, and I think that the court should determine them, obviously with assistance from the parties, and then make sure the parties are adducing expert evidence that answer the same question. I was going to make the comment, and I was going to, because we're no doubt out of time, and because we'll be coming to the end, but I was going to return to Kingsley Palmer's statements, which were the statements that I started with. But seeking recognition of native title is a legal process. That's unavoidable. It's a matter filed with the court, mediated by the court and determined by the court, and therefore the court's involvement in the framing of questions put to experts, I think, is fundamentally important.
Thank you, Judge. I hope everyone wrote lots of notes, because there are a lot of take-home things that we can practice or put into practice when we get back to work. So thank you so much, Judge. I'm not sure, I don't think we have any time for any further questions, is my reading of things. And I know that Tom's probably on a tight time frame because we've got him briefed on lots of things. So we might have to wrap it up. Thank you so much, Judge. It was really informative. We really appreciate that.